Well, hello, hello. Just wait for the stream lag to catch up. What am I looking for here? All right. Quick sound check before I continue on because I always boomer these openings. So there shouldn't be an echo though because I have the incoming audio muted, allegedly. So, but welcome. Hey, it's been a while. Law school's been hectic. It always is. I think the last time I was live was, November? Something like that? Maybe even October. But, December is exam season. And then you transition into, of course, the holidays are never a good time to do anything. And, January starts to transition into a new semester. A bunch of new law courses spun up. And here, let me move the microphone. This ever expanding law library. This ever expanding law library is, it grows every semester. So, I'm a little overexposed here. Let me kill the lighting just a little bit. I am not going to be here for very long. I got to dip out at 5:30. 5:30. Jesus. I'm still on daylight savings time. That would be that'd be 4:30 local time. That's right. I picked the middle of the stream to realize that I have not reset I've not reset my watch from daylight savings time. So, what a wonderful time to discover that. Anyways, how you doing, chat? How you doing? Like I said, I'm not going to be around for very long. I'll probably dip out 4:30 Mountain Time. I think that's 6:30 Eastern Time. Anyways, I just wanted to announce what is going on with this channel because I'm not abandoning it, not yet. Anyways, I certainly wanted to introduce everyone to something I have teased for a little while on other LawTube channels. I was talking to Good Logic about it. Shout out to Joe. I was just on the MLS stream, making law simple with Dave. I wasn't on it as a panelist. I was just hanging out in the chat, telling everyone about this new project. But it's called Everything is Political. Yes, it is approved by. You know what? All Canadians. We were implanted with the chip at birth, and so we have this direct line to Trudeau. And so, if he didn't approve, he'd just zap my head from Ottawa. He's got this. He's got like a stream deck sitting at his computer, and he can just hit buttons, and he just instantly Hillary Clinton's people. So, anyways, just it's always fun talking with chat, but they knock me off the topic. It's all your fault, chat. But yes, the Everything is Political show is a new show I'm starting in the run up to the 2024 presidential election and an anticipated federal election here in Canada. Because who likes a good Canadian election? No one? Okay, just me then. But if you've watched the previous content I've had on this channel, yes, I do talk about Canadian elections. We have a few scheduled for this fall, and I hope to provide some commentary and coverage on them. I will absolutely be doing commentary and coverage of the American presidential election. But there's not a lot to report on because I'm not interested. There's not a lot of commentary a Canadian law student can offer on Trump's legal cases. I defer to a lot more learned lawyers in that realm, especially American lawyers. So there's not much for me to talk about there. But what always fascinates me is the political data that people generate, and going into the numbers and a breakdown of how certain things come out to play. Certainly, I'm sure people are curious to know what's driving a lot of the trends in some of the states. It's never a substitute for kind of your ear on the ground, but sometimes people they they take. It's very easy for them to come to a certain conclusion and then not have the facts or the evidence to support it, and they're just kind of going on their gut instinct. And sometimes people really appreciate having that justification for what they see on the ground, and I hope to provide that in some way. Anyways, Everything Political is a show that's going to... it's always going to feature a guest. I don't have a guest lined up today because this is just the teaser of it. But it's always going to feature a guest that we talk about how everything is connected to politics or public policy one way or another. I want to grill my guest on what underpins their political values and beliefs, and how do they extrapolate from that into the greater, here's my stance and my decisions on public policy. The idea that everything is political is that originated from a argument I had with Nick Rekieta in his chat. I think I super chatted a very long time ago about how he hates how a lot of issues have become so politicized. A perfect example of that is there's certainly a lot of distaste and distrust around scientific research, and it's unfortunate that it's become so politicized. Journalism has become so politicized. My argument is that they have always been politicized. Every single thing that you will rely on to make a public policy decision is in its inherent nature political. So you can talk about just about any topic that affects people's lives, and you will find political slants and political biases. And that's what I want to explore with this new show. Now, for the first couple of guests, I've had some of the law tubers indicate interest that they're willing to come on and talk with me. I'm not sure they quite know what they're getting into, because usually I just get a shout out in their chat, and he's like, yeah, send me details. I'll come on. So, I can always send them this video as the primer, but essentially it's going to start off with some questions that I've supplied and provided ahead of time. Those questions typically are, how are the methods that you were, values you were taught or passed to you in your childhood. How have they informed some of your belief systems as they exist today? Especially for people who have very strong religious upbringings, their religious beliefs will feed into what they value and what they believe in. So, the the conversation will always have natural breaks in that process. There will be a lot of follow-up questions. I think the most common question you're ever going to hear come from me as the host and the interviewer is going to be, well, what do you mean by that? Can you give an example? Because a lot of people will say, I have this, overarching value and belief, and that's just not good enough for me. I want you to, okay, how do you apply this when you go into decision-making? And politicians have politicians have the one of the hardest jobs in the world, in that they have to make decisions sometimes that benefit people, most of the times that benefit themselves, but they often have to do so with imperfect information. And one of the ways that you can sort of soften and cushion that is waiting for more information. And that can explain why things take so long to make it through the legislature, because if you're making a very large, public policy position, you're bringing in legislation to support it. You certainly want the justification to do so, and with imperfect information, there's not really going to be good justification. You can't just say, well, this is what I believe in, and I think it's the best for the country. No one's going to buy that. So this is kind of riding the coattails of that concept and bringing it over to the rank and file people who make opinions on political topics. So, everyone knows all about the whole Taylor Swift, Joe Biden thing. So, she is so, of course, I'm not going to pretend that I'll ever interview Taylor Swift, but she would be a good example of someone to bring in and start grilling them on, okay, so why? Why is this what you believe in? How does it align with your personal values and beliefs? And when they start talking in the super abstract, it's going to be my job to just kind of, whoa, hang on. That's a little too abstract. Why don't we, give an example? Or what do you mean by that? Expand upon that. And through that, a lot of people will, I'm not hoping to change minds, and these are not debates in the sense of the word. I think what will come out of a lot of these interviews is a better way to argue your own personal beliefs and convictions. Because when confronted with someone who's saying, okay, now hang on a second, you said this, and you made an assumption, but what if that assumption is not true, or I don't quite buy that assumption or presumption is valid. And so what do you do in the face of that? And you start challenging people to, okay, so set the assumption aside, do you still arrive at the same conclusion? Sometimes people will say yes, because, I just have this gut instinct about this thing, and it's reactionary sometimes. Other people would say, I've had a chance to observe the evidence, and if my assumption or my presumption is false, I'm willing to change my stance. We see this is what I have pulled up on the screen here. We see a very good example of this. So what I have on the screen right now is it's the judgment that ruled that Justin Trudeau's invocation of the Emergencies Act was unjustified and unreasonable. And this is a massive document. It's 190 pages. So I will not have enough time to go through everything here. But I just want to scroll down to a specific page. We'll first just kind of look at the style here, because this was a huge case. You can see it's encompassing a number of dockets, and this decision covers all of those dockets. And you'll see the parties here. So we have people who, and for those who don't know, this all relates to the 2022 Truckers' Freedom Protest, the Freedom Convoy, that occupied downtown Ottawa. There is mention of the Coutts blockade in Alberta, which took place at the Alberta-U.S. border with Montana. And there's also mention of the Windsor Bridge and the Sarnia Bridge blockades that blocked the U.S. border between Ontario and Michigan. The Ambassador Bridge at Windsor, I believe, is one of the most valuable crossings, land crossings, in terms of international trade. I believe the number is cited somewhere in here. It's a ridiculous number of trade. I think it's either tens or hundreds of millions of dollars that trades between the two countries every single day. And so there was there were two key pieces of info I wanted to highlight. Number one is going to be, I think it's on page. I highlighted it. Whoops, too far. Because I highlighted it. There it is. So, paragraph 281, page 95. You're going to... I'll unhighlight it, but there is something here that really caught my attention. So one of the hallmarks of the Emergency Act is there is it relies on the CSIS Act. The CSIS Act is what it's the statute that creates our intelligence agency. CSIS is our version of it's kind of a combination of our FBI and CIA in a sort of way. It handles domestic and foreign intelligence, but we don't do a whole lot of foreign intelligence work. And our military might handle other intelligence work. Like, we do have a special forces, a branch of our military. So, it's not quite a perfect fit in terms of what they do, but certainly CSIS is our domestic intelligence agency. And so they would perform the actions and functions similar to the FBI. One of CSIS's main prerogatives is that they combat domestic terrorism. So, I believe CSIS is under if I recall correctly, they are under the branch of the military and not the National Police Agency. In terms of like who they report to. Anyways, that's not very important. But it's the definition in that act that defines a national emergency to invoke the Emergencies Act. So that definition requires, in the paragraph above, right, there's a huge discussion on, what is the definition of substantial harm, serious threat in terms of national security. And so they look at two things: substantial risk of substantial harm, and risk of serious property damage, or what they call serious violence to property. And so the court has had to define those terms. Here it is. It is cited here. CSIS Act. Yeah. So, so they talk about the, what is the level of serious violence? And the judge agreed with the government of Canada that the level of threat does not have to rise up to threats of violence, actual violence, rising to the level of death and endangerment of life. So there's a risk of bodily harm is not rising up to the level of death or endangerment of life. But the risk of bodily harm meets that definition for a serious national emergency. And now these are just setting up the parameters, right? Setting up the goalposts, and then the judge will show where, turn away, Lions fans, but the judge will then proceed to say whether Trudeau made the field goal or not, so to speak. This is the thing I wanted to pick out, though. The serious violence to property could encompass several offenses in the Canadian Criminal Code relating to destruction or damage to property, including critical infrastructure. So, the critical infrastructure is a defined term. They give a couple of examples here, right? Electric grid, national gas supply. Attacking the structures that provide the comforts and necessities of life. Railways, pipelines, right? Those are other examples. Power stations. Those would all ports of entry. Attacking the port of entry with the goal of rendering it unusable is quite a different animal than simply blockading it. And as the court distinguishes here, it says, there is no authority in Canadian law in support of economic disruption sliding in under the definition of serious violence to property. And this is, I actually had a quick chat with a law professor about this. I was able to persuade them that, our charter has a lot of protection for speech, but the economic interests of those speech are not nearly as protected. Don't get me wrong, commercial speech is definitely protected speech, but if the speech itself is not infringed, merely your ability to profit from it, that has a lot less treatment in our courts. And we're seeing a sort of confirmation here. Our courts have never found that purely economic positions are able to survive, are a right that is owed to either the government or the Canadian public. And I thought that was really interesting that they're sort of expanding upon that here. The Supreme Court citation for this economic authority would be Royal Oak Dentistry. It's something that came up when I was writing a factum last semester. But in there, Justice McLaughlin, as she was then known, because she was our Chief Justice as well, and so in Canadian formal parlance, when you're doing citations and addressing judges, you always cite to the judge who made the statement when they made the statement. If they have since taken a higher level or a higher role within the court, you would add on as they were then known. That's sort of a formality in when you're doing citations. So Justice McLaughlin, who later became the Chief Justice, but she was not the Chief Justice when she wrote that decision, and so I would cite it as, when I go to quote it, I would say Justice McLaughlin, as she was then known, wrote the following. I'm going to paraphrase it because the exact citation is a little wordy, but the paraphrase would be that in the case where dentists were trying to advertise services for their office, and she wrote that advertising for the economic benefit is not protected by the charter. However, there are other reasons a business may advertise, such as informing the public about the services they offer or their hours of operation, in which case they are merely passing information as opposed to a solicitation for business. And so if you read between the lines there, again, this is this idea that economic activities don't enjoy the same protections as many of the other activities. And there is, in this case, if you read through the whole 190 pages, you'll see a very comprehensive breakdown of the freedom of assembly, the freedom of expression. There's unreasonable search and seizure, engaged, Section 7, enjoyment, protection of life, liberty, and the security of person, that also engages the Canadian Federal Bill of Rights. And you don't see that come up very often because it was superseded by the Charter. The Charter's constitutional law. The Federal Bill of Rights is simply a federal statute. However, because the federal statute has in its preamble any law that does not discharge its, any law that is invoked notwithstanding the Federal Bill of Rights shall fall under the purview of the Bill of Rights. And one of the things in the Bill of Rights that is not in the Charter is your right to the enjoyment of your property. And that relates to the freezing and seizing of the bank accounts. Now, the judge in this case did find that the freezing of the bank accounts exceeded the government's authority, and it was unreasonable. And so they granted remedy to the people. Like I said, a very complex case encompassing multiple parties and dockets on file. one of the remedies, or sorry, no, the judge has not ordered remedies yet. They're doing subsequent submissions for costs. You can see by the date stamped on this. I don't know if I showed it, but it was. This was a very recent decision. This was released 7 days ago, so it's a week old now. And so the court is waiting for submissions for any possible costs or damages. I don't expect that there's going to be an outright damages award. This was a public interest suit, and so I think the only order for remedies is going to relate to costs, if any. Certainly the findings, though, and the government has indicated they're going to appeal. This was tried at Canada's federal court, and so we're expecting an appeal up to the Canadian Federal Court of Appeals. After that, it goes to the Supreme Court if there is a judgment and right of appeal after that. This was a judicial review of that. Of the governor and council decision. And so this really relates to the administrative law realm of Canada, but it also hugely engages our constitutional law as well. So the standard of review, and there's been a lot of kind of movement on this lately, recently in the case of Vavilov, but although Vavilov doesn't apply to this particular case, but it's a good example to illustrate the sort of the fluidity of the standard of review. Reasonableness appears to be the standard that was applied in this. I think that you'll see that in the decision where they talk about the standard of review. Simply, if you come, again, the discretion is always given to the government to act within their limits of the statute. Now, the finding that it was also unconstitutional is impactful in terms of if you fail that administrative reasonableness test, you still have to reconcile the constitutionality. If something is unconstitutional, it is by default unreasonable. And so that was the judge's way of saying, okay, to show I've done a thorough analysis, I'm going to make these several rulings. So they're not superseding and they're not moot in regards to each other. They're all relevant, and they're always relevant, especially when you go into appeal. It'll be interesting to see the factums that the government and the government will be the appellant, and then the Canadian Civil Rights or Civil Liberties Association will be the respondent. So it'll be interesting to see what the factums they submit look like. In any case, the other thing I wanted to jump to is right down to the conclusion. This is just the law. All federal laws in Canada are in both languages, English and French, and so that's why they look like this. But that's in the appendix. I went past the judgment. So the judge is disposing of several of the parties here. Some of them don't have standing. And standing in this context is really, really hard to explain. I don't have enough time to cover it. I've only got about 15 minutes left before I gotta head out. This was the finding, the ultimate finding by the judge. And I really wanted to highlight this part because it shows that the judge may have been swayed by, the judge had come to a conclusion ahead of time, and no one pretends that judges are not allowed to have opinions. And I think this is an excellent illustration of a judge admitting, look, I may have had an opinion before the case, but I decided the case on its merits with the evidence in front of me, and that has caused me to change my opinion. And that's kind of the goal of what I want to do for Everything is Political. So, just to read through here, my preliminary view of reasonableness of the decision may have prevailed following the hearing due to the excellent advocacy on the part of the counsel for the Attorney General of Canada. So, much like AGs in the US, right, this is our top lawyer, so to speak. So, the Attorney General is the representative of the Canadian government in these proceedings. Had I not taken the time to carefully deliberate about the evidence and submissions, particularly those of the CCLA and the CCF, this is the Canadian Civil Liberties Association and the Canadian Constitutional Foundation. And so these they were able to be granted standing in this case due to the public interest doctrine. So mootness was one of the issues that the government brought up. They said the Emergencies Act is over, there's no live issues, and so the case is moot. But the judge granted standing to these two organizations and several individuals on the basis that there was a public interest in pursuing an outcome on the basis of the evidence. And so that would override the presumption that mootness should result in dismissing the case. Again, that is described, that is analyzed further up, and if I had time, I'd go through the entire decision. I certainly see a lot of things that, as a law student, I'm seeing these key pieces of information that were taught in our law classes about, finding things that are constitutional in the administrative context, looking towards reasonableness. Discretionary exercises of power by the government, especially the executive branch of government. This is all of this engages that executive branch. This was a governor and council decision, which means that similar to like a executive order by the U.S. president, it's engaging that similar power. And so obviously when the courts review that power, they defer the discretionary power to the executive because that is in the interest of the separation of powers. However, decisions which are inherently unreasonable should be reviewed and overturned by the courts, and that's what we had here. So their participation in these proceedings has demonstrated again the value of the public interest litigants, especially in presenting informed legal argument. This case may not have turned out the way it was without their involvement, as the private interest litigants were not as capable of marshalling the evidence and argument in support of their applications. So that's just, again, hitting on the importance of the public interest doctrine. I have concluded that the decision to issue the proclamation, again, that's what we call them royal proclamations, but that is our executive order, does not bear the hallmarks of reasonableness, justification, transparency, intelligibility, and was not justified in relation to the relevant factual and legal constraints that were required to be taken into consideration. The way the judge worded this, he's not attacking the law itself. He's not attacking the empowering statute. He's simply saying this particular use of it does not bear the hallmarks of reasonableness, justification, transparency. In my view, there is only one reasonable interpretation, and the applicants have established that the legal constraints on the discretion of the governor and council to declare a public order emergency were not satisfied. Here's the finding of lack of standing for the Canadian Frontline Nurses. That's a not-for-profit organization started by I think this individual here. And it was kind of like a very small advocacy organization that claims that nurses were fired for refusing certain, mandatory things that the government had ordered. These two individuals are ones that had their bank accounts frozen. And so when the judge found that it was unreasonable to order the emergency, also the order to freeze bank accounts by virtue of the unnecessariness and the unreasonableness of the, umbrella superseding order by transitive property, also the order to freeze bank accounts was unreasonable. Is this opening a door for people to sue the federal government? It's possible. It's possible. Whenever rights are breached, in the criminal context, when your rights are breached, the remedy is often the exclusion of the evidence. If the breach is of the type that would shock the moral fiber of the community, it sometimes, the highest thing is just to declare a mistrial to stay the proceedings against an accused. I unfortunately don't know enough. I haven't learned as much in our in the Canadian law school how this would relate to civil remedies, because these are civil breaches. The damages against the damages against the people whose rights were infringed are civil in nature. They're not criminal. They didn't face criminal charges. So it's going to be interesting to see if this order has opened an avenue to file a lawsuit against the government to recover damages that flowed from the unreasonableness of this decision. The government may have the ability to dismiss those cases based on, hey, we acted under the info that we thought was correct at the time. Just because you have the benefit of hindsight doesn't mean that the damages warrant recovery from the government. So I really just don't know where that will go from here. It'd be interesting to see what Runkle has to say about it. But I think I'm going to wrap up right now. I just want to do this really short video, talk about the show Everything is Political, do a quick deep dive on the Emergencies Act. I'm not planning to do a more comprehensive analysis of this simply because there is so much about this decision I don't know enough about to really get into a complex deep dive and analysis. But I could be persuaded to change my mind like the judge here did. I could be persuaded to change my mind. It depends on what my audience wants to hear. So let me know. Is this something you guys want to learn more about? You want me to go through? Do you want me to defer off to people like Viva Fry or Ian Runkle in this? By the way, I was watching Runkle's birthday stream and watched him advocate at the Supreme Court. I was kind of trolling him a little bit. He's got his crutch words essentially in terms of. And I just finished last semester. I was working on an appellant moot, and that was something that the instructor really, really hammered us on. Just every time we did it, she'd point it out. She'd say, "You said actually, you said regardless, you said essentially, this many times." It was eye-opening. It was really eye-opening. There were a couple of students in there who overused the word "like." We all know the, and then there were some very talented orators in there who did not rely on a single crutch word. I'm not going to tell you where exactly I fell in that spectrum. I do note that I received a fairly good grade in that course. Definitely not an A+, but I'm happy with the final grade I got in that course, and I believe that I put forward a very strong performance at the oral hearing. I did my very first criminal trial opening statement recently, and man, oh man, and we had a jury. We had a bunch. It was a moot, of course. It was obviously a moot. We had the other students in the class sit as jury members, and they just sat there and watched you go through your opening statement. I was on defense, and I had someone opposing me as Crown or prosecutor for my American audience. And I'll tell you, you never know how you're gonna feel. You never know how you're gonna do until you get up there. Until you get up there and do it. And everyone feels just a little queasy in their stomach, a little nervous. But I found that most of us shook those nerves off. Like, they had a couple of nervous tics, some people pointed out. We also had to all submit notes to the instructor to give feedback as we watched the other students do their presentations. And so a lot of people would kind of notice, you're tapping your foot, or you're clicking a pen, or you're not making eye contact, you're staring down at your notes or your computer too often, things like that. And again, there are some people in there who would make awesome trial lawyers because they speak in a way that really engages an audience. And then there are people who you could tell they were nervous. They'd never done anything like this before. Um, I'm glad, I'm glad I have a lot of experience kind of talking to a camera. I've done, public speaking, public debates before. Um, I'm kind of lucky in that regard that I go up there, I'm confident in the soft skills, the ones that are hard to teach, right? Make eye contact, be engaging, control the tone, the speed of your voice. I probably don't do that as much when I'm on camera here, but certainly when I'm in person. And they really harp on the whole hand gesture thing. And I'm bad for that, but I know I'm bad for that, and so I'm able to I'm able to deal with it when I'm doing moots. So I've not had a professor tell me that I have excessive hand movements, but that is definitely something I do. I know I do it. I don't know, maybe it's that part French that every Canadian is born with. I don't care how English you are. You could be descended from the royal family, right? Your last name is Windsor, and you still, if you were born in Canada, you are a little French. Anyways, I'm gonna call that a wrap. I hope you guys enjoyed that. As always, leave a like. Share it share the stream if you thought it was interesting. Let me know in the comments. Let me know if you want me to go into a deeper dive on the Emergencies Act, and please do watch out. I don't have the date for the first premiere. I do think I have a couple of people who have said they're coming on, so I'm not sure which order I'm going to release them, but I don't have an exact date for the first episode of Everything is Political, but I do hope to get it out before February 15th. Or even February 14th, Valentine's Day. I'll be hanging out in Good Logic. Joe Neerman has a 24-hour stream coming up tonight. I'll be hanging out in that chat. I'm hoping he'll send a link to get me to call in, because I certainly want to talk about Everything is Political with him. I'd love to talk about election stuff, election polls. But anyways, we'll see you guys around. Until next time, stay frosty, everyone.